Yes. Can you hear me? Hello?
Hello, my lord.
Yes?
Okay. Yes, you can hear us.
Okay, now I can hear you. Akwan,
Yes, my lord. Good morning, my lord.
no, good morning. How are you? Please go ahead and call the case for the Lana Silk.
Yes, my lord. Resume today, Wednesday, 15 July 2026. Before His Lordship, our Justice R.H. Gwandu residing. In suit number NICN/LA/124/2026 between Mr. Charles Ramufu Ojo and Central Securities Systems Limited, PLC, sorry. Lord, the matter is for us. A parties in courts
Matter is for.
is for hearing of motion, my lord.
All right, all right.
Law parties are absent.
What is the upset? Yes, Lana Silk.
So, my lord, I think I must mention that the defendant is represented in court. Yes, the defendant is represented in court by, I think, a legal officer from.
Yes, my lord.
Don't know whether it is. Okay, yes, the defendant.
Hello, I'm speaking. Oh, can you hear me, please?
Are you the counsel for the defendant?
So, no, I'm the counsel for the defendant, but the defendant.
You are the counsel for the defendant, yes?
Yes.
She's representing. Okay, I understand. I understand. Is the counsel for the claimant, are they here? William, why is the counsel for the claimant?
I'm representing the claimant, and I can't confirm that the claimant is online, my lord.
All right.
I am the counsel for the
claimant. May I have your appearance?
My lord. The claimant is actually online and present, my lord. Mr. Charles.
Morning, my lord. Morning.
I don't know his department. So the claimant is in court and the defendant is represented, my lord.
No problem, no worries. I'll call you. Okay.
All right. Yes, claimant's counsel. Sir, can I have your appearance?
Good morning, my lord. My name is Adejoyi Afun.
Okay.
Appearing with me are Michael Abiba and Jemima Edie. Our appearance is for the claimant, my lord.
All right, fair enough. All right. Yes. Is the license appearing with anybody?
Yes, my lord. With the proper respect to my noble lord, and also appearance for the defendant, for Lavikuti, with me is Francis Obey Jessica.
All right.
We both are now for the defendants, yes.
All right. The last adjourned date, I ordered for them to file their response to the PO. So I don't know whether they've done that.
Hello, please mute yourself temporarily, please.
Yes, my lord. I confirm that that has been
filed. You confirm? Hello?
My lord, indeed.
My lord, I confirm that we have filed.
Okay.
So, my lord, indeed, as of today, there are two pending motions for interlocutory. So there are two counter applications, both seeking to achieve the same objective, howbeit for the respective clients or parties that we represent. All the papers have been filed on both sides. The applications for interlocutory injunction, the responses are all in, and then I will be asking the lordship to let us have a combined hearing on both. We are all our papers in. We we do not have any housekeeping application, but I reckon that they have an housekeeping application they need to
All
take
right.
first to clear
All
the
right.
stage for the hearing.
All right.
Lord, I'm happy that the Leonard Silk has given an update on the background. For me, my Lord, my humble application was that the both applications seek the same objective, I bet, for different parties. And if the Leonard Silk is minded and to not waste the time of this honorable court, I want to humbly propose that we clear the course for a speedy trial, and so that parties avoid, because if my Lord does find merit in our application, he would have closed out his own application. And even if they're both taken together, they seek to achieve the same thing. If I may provide guidance, we are asking for an injunction that the vehicle that was provided to the claimant should not be taken from him. They are seeking to take the vehicle and ask the claimant not to sell the vehicle. We are willing to provide an undertaking that the claimant is not intending to sell the vehicle, and that since the vehicle forms the fulcrum of the main suit, that be determined once we determine the suit. And as long as the defendants are willing to undertake that, they will not harass or take any steps to retrieve the vehicle, then my Lord can give us a clear date and we both withdraw applications. It serves justice if the Leonard Silk is amenable, but that's my humble recommendation, as since both parties have both applications ready for hearing. Thank you, my Lord.
Yes, Leonard Silk, you had him. What do you have to tell me?
My Lord, first, I mean, when I hear this sort of proposal being made in court, I'm minded to say that I wish things are as simple as straightforward as proposed. That application, if it was one that should be countenanced, or if it is one that should be countenanced by the defendant counterclaimant, is one that would have been discussed before the hearing. When the matter is set out for hearing, and a defendant is not just defending, he has a counterclaim. The position of the law is that if he seeks to have an affirmative order as to the reason, as to certain items being returned to him, pending the determination of the substantive matter, he must file an independent application. So the fact that if your lordship takes a position on their application and say that it is not meritorious and it is declined, does not automatically translate to the defendant counterclaimant in this case having to have returned to him or to her the following items: laptops, work tools that are items of the employer at every point in time, ID card that is an item. So it goes beyond saying vehicle. We need to look at it in the context. So this sort of proposal is not one when the matter is for hearing. The understanding is that it is for hearing, and the easiest way, the easier way to clear the coast in the circumstance is to ensure that there's a determination one way or the other on those items that we think they're very germane to have courts pronounce on who should continue to be in custody pending plenary hearing of the substantive issues submitted to court. If it was simply a vehicle, it's a different thing. Even if it was simply a vehicle, there's still a need to satisfy, because it is being held by a party who, by the nature of the papers before the courts, at the end of the matter, is more unlikely to be able to sustain what the defendant says will be looking out for. So, my Lord, ordinarily, I have minded at any point in time to go to the substance of a case and dealing with the injunctive orders, but there must be a quid pro quo as to the issues being submitted. The instruction I have from my client is that there are properties that they should have, properties that contain sensitive information, confidential information, should come back to them before the matter is determined, unless the court says otherwise. So that is the reason why we will not be amenable to the suggestion or the proposal that there is no determination on the injunctive application.
All right.
Thanks so much.
My lord, if I may provide clarity on the points, I have no objection to the angle the Learned State wants to take. And like I said initially, it is to clear the coast. In the Learned State has made reference to car, ID card, and laptop. We have provided in response to these issues. The laptop, sensitive information, as it says, have been deactivated from their end. So it's not as if we are holding on to things. So this is a gentleman, a legal professional that's been in their occupation for over 10 years in sensitive position. And as a legal practitioner, he's bound by confidentiality. But if Learned State wants to move the application, the matter today is adjourned for hearing of our own motion. And that is what we are ready for, my lord. We can take another date for his own application if my lord is so inclined. But if I remember from the last adjourned date, it was for hearing of our application, which my lord said we need to file a response to. But if my lord is minded to take both of them, we are ready to go on, my lord.
All right. I'll tell you how we are going to get down to this, because the aim of this court is to achieve justice. Justice must be done, and it must be seen to have been done. I would like to ask the two parties, how many witnesses does each one of you have? Lana Silk, how many witnesses do you intend to present?
Defendant counterclaimant is calling 3 witnesses.
All right. And you?
Your lordship would imagine with 3 witnesses, yes.
Hello? Hello?
Sorry, my lord.
My lord, we can hear you now.
And you? How many witnesses do you have?
Yes, my lord. I reckon that
we have 2 witnesses, my lord.
So we have 5.
Is now being
Can you hear me?
Yes, we can hear you, man.
Akpan, what is happening there? You are whispering, you are interfering. Yes. So we are going to hear all the 2 applications, and then we'll adjourn for a ruling, and then order the matter for an accelerated hearing. That is the only way to attain justice in this matter. So you go on ahead and move your motion.
We have housekeeping application. I would like to be guided if we should take that first before
Yes,
moving
go
the.
ahead. Of course, you have to take that first.
Yes, my lord.
Are you hearing me?
Yes, I am hearing, my lord. I'm just trying to identify the document. I do apologize, my lord.
All right. All right.
So apologies, my lord. I was off briefly, and the last 2-3 minutes, I was off
You are off the.
from this, and I did not hear anything.
Oh no, sorry about that. We agreed for him to move his housekeeping application,
My Lord,
and we are going to hear both applications.
yeah, my Lord, my Lord, apologies. I was off briefly. I even thought he was. Yes.
The
Okay.
network is terribly bad.
Thank you so much.
Lance, what are you saying?
Tell if it's a disconnection from my hand or from the
I think it's from all ends. It's a
court
total
server.
network. The network is bad.
As a places, those are some of the
Because
challenges that we still
what
face
you
with
said after you told us that you had
exactly.
been shut down out for some time, I couldn't hear you.
Yes, yes.
Mhm.
As a couple. Thank you so much, I love that. But I'm back now.
All right. Have you found the document? He was trying
My
to
Lord,
identify the document we are talking
yes, I
about.
found the document. I'm just trying to download it. I do apologize, madam. I had it here before, but I don't know what to do.
Okay. So go ahead and make the housekeeping application.
My Lord, I apologize, man. I found it, my Lord. We have an application, my Lord, dated the 2nd day of July, 2026, seeking an order of this honorable court extending the time within which the claimant applicant may file and serve the claimant's counter affidavit opposing the defendant's motion, which is dated June 9, 2026, and as well as an order deeming the applicant's counter affidavit opposing defendant's motion or notice dated June 9, 2026, already filed as deemed properly filed and served, my Lord. The said application is supported by a 6-paragraph affidavit deposed to by Rafi Abbas, and there's a written address as well supporting of the same date, my Lord. With the kind permission of this honorable court, I beg to move in terms of the motion paper.
All right. Any objections, Lion Silk?
No objection, madam. No objection.
It's granted as prayed.
As God blesses.
As the court
Okay.
pleases.
Okay. Yes. So let's move on. That's all.
That's all, my Lord. The
All
plaintiff
right.
has the motion and notice dated.
Sorry, my Lord. Apologies, my Lord. Apologies. Just a minute. My Lord, I was off briefly for about 2 minutes, and what I wanted to propose, subject to your Lordship's overriding wisdom and then accommodation, is that in this sort of cross application for interlocutory injunction, to help case manage, it is advisable to have whoever starts take his interlocutory injunction, move the application for interlocutory injunction, and touch also in response to the application of the adversary that is also seeking an interlocutory injunction. But again, it's subject to how your Lordship wants, so that we are not having to respond to this and then we go through the same cycle again. I mean, but again, it's subject to what your Lordship Good. I'm ready
I think
to
that's a good idea.
proceed.
Let's do it that way.
Yeah. Yes. But substantially, we are seeking the same thing, albeit on other states. Yes.
I would seek that we take them in isolation because issues are different. Because it would mean that we would take our application, then start referencing their documents and everything. My lord, they are separate applications, and my lord can look at them. If my lord is minded, we'll prefer to just take the application, go through the second one as well, and counter it accordingly, my lord. It will be it's better, it's neater that way, my lord, if my lord is most guided, subject to your overriding position, my lord.
All right. What will happen is whoever moves first, the other person will respond to him. And then like that, then we'll go to the next application. I agree to that.
God, please. Most obliged. My lord, the claimant has an application for this honorable court. Senator Lakruchi application seeking two major prayers, my lord, mainly an order of interlocutory injunction. I must apologize first and foremost that on the face of the motion itself, it is written as an order of interim injunction. But it's a client error and typing. If you look at the written address itself, my lord, which we'll see, it is actually properly written as interlocutory injunction. And we humbly seek the approval of my lord to replace interim motion with interlocutory, and the justice. We've written a letter to this effect and served the defendant as well as the court. So I will be guided, my lord, if that prayer can be determined one way or the other. And if the defendant has any objection, that should be determined before we proceed to move the motion. Or do we move the motion and then my lord takes everything together?
Yes, Lance, what do you have to say? Hello? Hello?
I can hear you, my lord.
No, Lance, look, it's not with us.
He's still online, my lord. I can see. Let me hear.
Maybe he's Hello, Lance. Williams, please, can you get his attention for me?
Okay, my lord.
Mm-hmm. Yes. No.
My lord, apologies that I was looking at the question. I was logged out and I had to come and use my colleague's device.
Yes, Lance, are you here?
Yes, my lord. Yeah.
We lost you some time back.
It was locked out. Sorry, my lord. So what's the question, my lord? I'm too sorry.
Leonard, we had made an application and
Yes.
seeking to amend the clerical error on the face of our motion paper, where reference was to interim instead of interlocutory. I did make reference to the fact that the written address actually intention of the application was. I also notified the court that we had written
Let me
a letter explaining this to yourself.
let me do it. Let me do it.
If I may finish,
I don't have an objection to it, so you don't need to. My lord, what is fair is that they are written to me before now. Even though that will be taking the wind out of the sail of some of the argument that I've put forward. But I'll proceed so they can replace. You can go ahead.
Okay.
Thank you, man.
Thank you. Yes.
Thank you, Leonard. So, my lord, if I may proceed accordingly.
Go ahead.
Okay. Thank you, man. On the premise that our application for the amendment of the clerical error has been approved granted by my lord, we have an application here seeking an interim order. As the corporation, we have an application seeking an order of interim interlocutory injunction restraining the defendants, whether by itself or through its agents, officers, servants, employees, previous nominees, and any other person or persons howsoever described, acting on his instruction on his behalf, whether directly or indirectly, from repossessing, seizing, or otherwise interfering with the applicant's possession of the status vehicle stated therein, a laptop, also the serial number provided, and an AirPad accordingly stated there, being assets consistently and duly amortized by the applicant in accordance with defendant respondents' applicable policies, pending the hearing and determination of the substantive suits. We're also seeking an order of this honorable court directing the defendants, whether by itself or its agents or any other person whatsoever, from desist from making, issuing, or acting upon any threat or demand for directive for the repossession or recovery of the said vehicle, laptop, and AirPad, pending determination of substantive suit. My lord, the application is supported by 5 grounds, and the application is dated May 21st, 2026. In support of the said motion, we have filed an affidavit in compliance with the rules of the court. We have my lord there we have filed a 26-paragraph affidavit along with exhibits A to L. Also, we have filed a written address of the same dates. And my lord, also the claimant in support of said application has filed a further affidavit dated the 2nd day of July, my lord. And as well, we've also filed a reply on points of law, my lord, of the same date. My lord, the plaintiff's claim is simply that he was in the occupation of the defendant for over 10 years as company secretary and legal advisor. Events led to his unlawful termination, which led to this came before this court. And he is mindful of the fact, or is fearful, my lord, that steps will be taken to retrieve some of the tools of office, which as a matter of practice, as we'll demonstrate in the substantive claim, my lord, are entitled to are made available to employees of the company as and when they leave. We only seek to move in terms of the motion paper and the further affidavit, my lord, in support of the application. So pray, my lord.
All right. Yes, livestock.
My lord,
And if I may interject.
Yes, sir.
Livestock, is there no way this matter can be settled out of court?
My lord, At the risk of modesty, but perhaps to emphasize a point, I regularly appear for the industrial court. I mean, more than many lawyers. I handle matters for both employees and employers. And many times, and I mentioned that to my learned friend on the other side, many times matters of this nature are resolved out of court long before matters are gotten to this. And then, my Lord, I can, thankfully, I mean, matters that have gone to court, there is no issue of confidentiality. I can readily, on top of my head, cite about 5 cases that similar circumstances, colleagues involved in different multinationals, different companies. At least I settled 3 out of court in Justice Hodges Court. So I can, and those cases are there. So when matters like this, I also believe that the best route is to find a way to take it out of court. In fairness to my colleague on the other side, he had reached out to me, and I salute him because that is the best practice that were taught. The moment he got my paper that we're filing in response, and we were supposed to speak, but somehow we didn't get around it. And I had informally informed my clients that I think this is a matter that at some point we could have a discussion and all of that. And they had said that, well, even if we're going to have a discussion, we will have to have it on terms and when the time comes for it. Lo and behold, the next report update I had to give the same client was another of these honorable courts injuncting my client from asking for. My learned friend had said, I like to put it in context. He had said unlawful termination. I would have said that is when the matter gets to substantive hearing. So, but if I can take a cue, the next thing was I had to go to them and send to them that, so there's an update that an injunction, interim injunction have been gotten against you to stop you from having your properties. My Lord, I like to speak freely. I'm happy that the claimant is there and then he's also a lawyer. Basic things as ID card and all of that, they belong to the employer. I don't think we need to get into law and all that. And I was going to address, but my Lord, I would have loved to address this when I make a response to this application, not even discuss my own application. When I make a response to this application, my Lord will see where my mind is going. But if I may quickly respond to what the Lordship has asked. And the next thing was, oh, they wanted to speak, but they went to court to get an injunction against us at a time when they've been served with our papers, demonstrating that we were not going to resort to self-help. So, my Lord, we got their papers. The law is that the counterclaimant can ask for an interim injunction. We could have filed an ex parte that we had written to say, return these items, and it did not. But my practice is not to file ex parte. I don't file ex parte application. I would rather ask the court that let the other party be. And I'm happy that I got vindicated on this. But I had to struggle to explain to them that, okay, maybe because we had to break down what was contained in the order. The order that was issued says the ex parte was granted. But somewhere in between, what seems to be diametrically opposed to the intent there would be that, oh, things were just to be status quo. But the best practice I was expecting is that when that matter came up for the hearing of that ex parte, if I was on the other side, the way I would have conducted that was to inform the court that there is no reason to believe that they will resort to self-help, because that's the basis of the ex parte in asking for these items, because they have filed before this court an application for interlocutory orders of injunction to have those items back. That is what should have been represented to court. And the court would, because those papers were in court. The papers that we want
But
to,
if I may interject at this point,
you explained it. When the application for the ex parte, so it should
and so
not
my lord,
there was, I'm coming here. I'll allow you. So,
No, but
if
these are issues which we've interjected Leonard.
I will let
So
me just finish.
let's not move the hand
Okay,
back. We've explained to you what transpired. My lord is so I don't want a situation whereby you're making it look like I misrepresented to my lord.
You would
The
have,
records
you have
are
an
there, and I did
opportunity
tell
to
you what
respond.
transpired.
He did not misrepresent
can I go ahead
anything.
to move the application, Melo? Can I go ahead and respond
Go
to
ahead, move the application.
I said yes. I mean, I wanted to explain it. So because it was at that point that they said that if this was done, clearly they know how to resolve this matter. Let's go on. That's the point I wanted to make. My lord, in opposition to the said application for interview, but my lord, in all, I hold a duty. I hold a duty to the courts, to the overall interest of justice on all sides, to ensure that if a matter can otherwise be taken out of court, there should be an out of court mutuality. The concern now is where we are. But I strongly believe, and I can say that, I strongly believe that if we put everything on the table and we're ready to give on both sides, the matter can be resolved. My lord, I can give my word on that. Employment matters are matters that are rather sensitive and not the regular commercial litigation that we do in other courts. And I recognize that. They are not the regular commercial. It is a matter concerning someone, an employee's life to an extent. I mean, Melania was saying that his work.
So in the life of his of the people that he's responsible to.
Absolutely, my lord. So I recognize that. That's why when I come before the court, I can say that I can beat my chest to say my records will tell. Every time I apply for, I appear for an employer, it is really when the matter cannot be resolved, and it will be shown that I've tried my best.
All right. So go ahead and move your application.
Yes, my lord. So I'll respond to the application. In response to the said application for interlocutory injunction, we have filed a counter affidavit deposed to by the group head employee experience services of the defendant respondent. It was deposed on the 23rd of June 2026. Deposed to by one Oladipo Oluyenka. Oladipo Oluyenka. And we rely on all the paragraphs of the counter in urging your lordship to refuse the application. In support of same level, we also have a written address. And we're relying on the written address as the argument in support. Well, if I could I'm not going to belabor the issue. I will just identify 3 things that an application of this nature must always address, because injunctions are not to be lightly obtained. And when I take on an application like this, what I like to look at is to satisfy the court that even on the best evidence put before the court, and I'll repeat that, the best evidence, the documentary detail put before the court to support that there's a legal right, that the balance of convenience is on the side of the applicant, that damages will not be enough, which are the 3 central issues that must be put forward in an interlocutory injunction. Those documentary evidence will readily tell that the case put forward by the applicant is diametrically opposed to what those statements are saying. And what do I intend to demonstrate with that? Well, like I said, I like to rely on what they put forward to ground your lordship's sympathetic consideration in granting the injunctive relief. My lord, I urge your lordship to take a look at Exhibit J. Exhibit J as the post as put forward by the applicant. Exhibit J is the letter stating that the individual is be removed, and it was asked within 24 hours to return 1, company's vehicle in possession, 2, company's laptop, 3, company's identity card, 4, company's iPad. I like to look at the last 3 that I mentioned, because we can come to the vehicle and discuss that in another context. My lord, in an employment that is arguably caught between master servants, where your lordship decides on the substantive issues that will come up for mature consideration at plenary hearing. If the applicant were to secure a successful outcome on the substantive case, my lord would not say that the applicant, the claimant, has a right of lien over a company's laptop, company's identity card, and company's iPad. This application has been put forward to say, my lord should restrain the defendant from having access to the car, to MacBook Pro, iPad, assets consistently and duly amortized. Assets of the company, of the employer, can never be amortized to be given to the employee. And I think it's important we have that understanding that I can hide the card. So this is what this application is saying. So I say that a legal right has not been established to that. Looking at Exhibit J. But my lord, I go a step further to also look at the status vehicle policy, which again, thankfully, self-same applicant has exhibited as Exhibit L. Exhibit L is the status vehicle policy. And what is instructive in Exhibit L is a particular sub-paragraph that says that at the exit of the staff, whether wrongful or unlawful, at the exit of this claimant, 15.15 says vehicle that is allocated to before the vehicle's depreciation period may, at the discretion of the management, the applicant may be allowed to purchase. My lord, I repeat that part. Before the end of vehicle depreciation period, at the discretion of management. My lord, we're not determining the substantive issue. We're just looking at the issues that do not require anybody going into the box. That is best evidence before the court. And it is clear. So if this clearly says that the management can even exercise a discretion to sell to you or not, clearly shows that on no basis, before the end of the depreciation period, can the applicant put forward a case to say, I am entitled to it? Because the case is, oh, those vehicles or those things have been amortized. And I don't want to be caught in what would appear to be heavy weather language. What is being amortized? What is important is, let's say it in the light of what is the duration, the period that you are to have it. And the case put forward by the applicant is demonstrated that, oh, that vehicle has been amortized for 3 years. That's what it says. But the documents that we demonstrated and some of the documents that he also put forward show that the vehicle, a 2022 model, was purchased in 2023, not a 2024 model. So if it was purchased in 2023, could not have been that. So it clearly shows that it is not just a status vehicle. It is a vehicle that the ownership, proprietary ownership, resides in the employer. Possessory ownership, because it's also argued that, oh, he made a contribution, arguably resides in him, and that is why he has it. And the employer has not moved forward. The employer will definitely not take any move to recover that vehicle.
All right.
Once the employer has not done that, we demonstrated that he has not even shown that he's entitled to have it. So you cannot come back though and ask the court to confer the right to have it on you. Because, my lord, this leads me to the issue of balance of convenience. Your lordship would rightly ask that it's a vehicle. The company can very well afford to, my lord, it is not just a vehicle, it's a status vehicle. What is the balance of convenience? It will be seen along the light of, as the applicant demonstrated that status vehicle is the only vehicle he has. And that if it is taken off, it will continue to walk on the road, it will be able to, and all of that. That is not before the court. Your lordship cannot assume It's a luxury car. So that's on the one hand. If the court decides on the substantive matter and the court says that that vehicle should or belongs to him, and we've said on the papers as of today, they have not shown proprietary ownership. If the court ultimately decides that, because he's always had it, there won't be any complaint. So it's more like that issue is taken care of. But if, my Lord, with all due respect, between the two of us, we've indicated today that we'll be calling 7 witnesses. We know the registry or how the courts, the dockets are getting heavily congested. So what that says is that there's a great prospect of a long gestating hearing in a matter that will be calling 7 witnesses. 7 witnesses could easily run into 3-4 years. My Lord, 3-4 years, 5 years, thereabouts. At the end of 4 years, if your lordship, or 3 years, if your lordship takes the view that that property, that vehicle belongs to the company, no doubt, it is an item that is subject to depreciation. We don't even need to argue with that. It would have depreciated substantially. And as between both, the authorities are consistent that it is a party who will be in a position to indemnify the order at the end of the day that should have the vehicle. And we'll put some of those before the court. My Lord, what we call undertaking as to damages. Supreme Court has repeatedly said it is not just a line that we conveniently put in an affidavit. It must be backed up by status to show that indeed, if the court finds that the vehicle belongs to the company, the applicant today, the claimant, judgment debtor as at then, will be able to, if it's depreciated in value and it cannot be used as status car by any other official, will be able to make the payment. And on this, my Lord, it wasn't cited. I thought I'll just mention, I was just looking at it this morning and I think it was just bang on the point. I already did an AG Commissioner of Justice, and it's a 1990 Supreme Court case where Waste GSC said where damages will be adequate remedy and the defendant will be in a financial position to pay the damages, interlocutory reduction will not be granted. Even if the plaintiff's case is shown to be strong at the stage of making the application, my Lord, the defendant is a public liability company, it's a PLC. And I heard the court to take judicial notice that a PLC would, it's not a private company that is likely to be dead. Even if it's a private company that is likely to be dead, there are provisions on how liquidation assets of those kind can also be made, can also be taken care of. It should not be granted. On the other hand, where damages will not provide an adequate remedy for the plaintiff, my Lord, if they can't depreciate in 3 years, 4 years, and the lordship say the company should have it, adequate damages will not provide an adequate remedy in the event of it succeeding. The court should then consider whether the defendants would be, whether the claimant, the defendant will be sufficiently compensated under an undertaking to be given by the plaintiff as to damages for the loss the defendant would have sustained by reason of the granting of the application. And it went on to say, there's no doubt that the determination by a court of where the balance of convenient rest is a question of fact and not of law. That was the case that the first said. It's a question, your lordship will consider the fact. What are the competing facts of both sides? And when I look at the legal rights, they said that, oh, legal right because the vehicle resides with the plaintiff. And also, they are supported with a decision which, again, defeats the whole essence. Akakwa Abi is a Supreme Court case where the Supreme Court even pointed out that you cannot create a state of affairs and come to the court to say this is state of affairs that your lordship should sanction. As I may, he had a notice. Give us within 24 hours. He didn't. And nothing was done about it for months. I mean, between when it came to court and now, nothing has been done about it. And that has not been done. And all the other items that were had. So that's, I look at when they say existence of legal right. I can't have been cited. My Lord, I've cited Ayoride. If we need to provide the full detail because he explained what it means to say, oh, he's providing undertaking, because they've said that they've written undertaking as to damages. And in all that we're saying there, We don't want the court to consider the merits of the substantive suit filed or that's filed on the part of the counterclaimant. All we are saying is that we let this hang in the balance and say who is likely to suffer more in the long run if the court finds that an order should not have been made, that it should continue to have that luxury status car. It was demonstrated that there's no such affidavit evidence before the court. Your lordship cannot assume. In fact, in one of the cases, it was said that it would be wrong for the court to assume that that particular item is the only one that the individual can lay claim to, as provided the convenience that he is seeking to continue to be in place pending when the matter is resolved. And in this case, there's no such affidavit evidence to show the court that this is all he has. All that they assume in the process before the court is we have a title to protect. And my lord, I said that title, even if it is secured in equity, if we concede that indeed you contributed, that is not the case. For purpose of argument, if we concede today that it contributed 90%, but there's a 10% that resides that's not been paid, that is that of the employer, and the employer is shown to be in a better financial position to be able to meet whatever damages at the end of the day, the law is that it's the employer that will have the vehicle. Because if anything, he is secured, then at the end of the day, he would have damages to deal with all of that. And I think that is why I wanted to illustrate what it means to give damages give an undertaking as to damages. The legal argument, my lord, it is, like I said, and you already has demonstrated, the discussion there is no law. It is a question of fact. And the facts must be borne out in the affidavit. How detailed is it before the court to say we will be able to do this? In fact, in one of the cases, it was said that undertaking, if the court decides to give that vehicle to remain with it, what the court will say that it should go and post a guarantee that they can meet or post a bond, not just put an affidavit evidence, because if the affidavit evidence is shown at the end of the day that he is not in a position in 3 years or 4 years, I don't assume they will not, but it's an individual. It's an individual as opposed to a company. And the company is not saying, the company is saying that you've not even come to equity with clean hands, because by your paper, it was obvious that you don't have the vehicle. You were given a lawful order to return the vehicle. When you did not do that, we came to court to ask the court to ask that you should return it to us. Despite the pendency of that application, which was sad on you, you went ahead to tell the court that let it be on status quo. And I said that if you go to the interpretation of what the Supreme Court said in those cases, status quo is not what you create. That is the account they are relying on. You don't create an affair, state of affairs before the beginning of hostility. And I say, court, this is the status quo, and court your action should be maintained. And that is the problem. That is the issue that I actually, at the moment that order was served on the client, and that we had to go over. And I think that is the reason why this application is being opposed, and we urge your lordship to refuse the said application. Thank the court.
All right, Council.
My lord, if I may have a short reply, my lord, I think it's very important to
But you filed your reply on point of law, haven't you?
And I'll
Council?
take it, my lord. Yes, we have, my lord, but they raised some facts which I think is good for my lord. We filed a reply to point of law, my lord. Yes, my lord. And a further affidavits which addresses some of the issues. But he touched on something which I think is important about the status quo application, which my lord granted. And it's very important we clear it, my lord. The ex parte application was filed before they served their response. It's a fact my lord can check. And the records of this honorable court will also guide, because Leonard Silka has made reference to it twice today, my lord, and respectfully, my lord, at the hearing of that ex parte application, my lord recalled that she refused to grant the application. And before I even moved that application that day, I told my lord, I said, my lord, the defendant has filed a similar application. I have a duty to bring it before you, my lord, which I did. And I said, since that application is here and everything is on the same grounds, to ensure that no steps are taken. And my lord saw wisdom and said, okay, status quo, maintain status quo. So for Leonard Silk to constantly go over it again and saying that because we had served, we didn't tell my lord that we had a private application, we now went ahead to move it. It's totally wrong. It's very important. this is a case of, this is what this honorable court is set up to protect employees. The fact that the defendant appeals, it does not take away with the way he wants to use a hammer to crush a fly. The facts are there, my lord. And without going to the substantive suit, the defendant served this company for over 10 years as general counsel and company secretary, a very, very prominent role, which he held diligently without blemish. All of a sudden, his employment was terminated.
My
and
lord,
he's asked within
our
24
point of
hours
law,
to
we are
return.
dwelling on facts, on substantive.
No. Leonard, I'm responding. Well,
where is your
I have to
hammer?
reply.
Yes.
You want to swat a fly with?
Leonard, let me finish. I didn't interject.
No,
when you were saying anything.
no, but I have
It's
a
because
duty at this
to
point not
raise
to allow
facts that
you
is
dwell on
important.
facts. It's our point of
You
law.
said no. No, I'm not. I say. Let me finish what I'm saying, my lord. Yeah, my lord, I wanted to point that point out. That's very, very important because it's mentioned it twice today, and we have other people hearing. On the important points of law, Leonard Silk has touched on the issues that said the facts of this case is important for granting his application. I'm happy he said that. And I urge my lord to look at the facts. The facts are simple, my lord. We've responded to every issue. On the issue, our application is for the status quo and the equipments which the staff and the claimant believes have been amortized or fully amortized, my lord. ID card, we have no objection to that. If my lord orders today, we'll make it available. We did not raise the issue of ID card. They raised it. So on that point, my lord, the facts are clear. We are even willing, if my lord urges, to provide an undertaking to cover what they are claiming. It's a car they are claiming. The policy is 4 years. They were in the 3rd year. And my client has paid equitable over and beyond the value of the car. We are of the opinion that we've even fully amortized the car. That is the crux of our application. But they are saying no. So, my lord, it is not as if we are not arguing issues like that. Whilst I don't want to go into substantive issues, my lord, it is just clear. And that's why I made the application at the beginning of this hearing. My lord, let's go into...
Yeah, I have heard you.
I'm most grateful,
I've
my
heard
lord.
you. Yes, I've heard you. It is all right. Let's move on so we can get it done.
Yes, my lord. So the other application before the court is the application of the defendant. My lord, we seek the protection of the court of my clients because I heard my learned friend say that this court was set up for the employees. And I know that the court at every point in time is doing so much to disabuse the mind
is set up for justice in employment matters.
So we seek the protection
justice in employment matters.
Yes. So
yes.
We seek the protection of the court.
Yes. No, you are well protected.
Yes, the interlocutory injunction is one dated the application for interlocutory injunction was dated the 9th of June 2026, filed 11th June 2026. And on the face of the said application for interlocutory injunction, we're seeking specifically 2 reliefs. One is seeking another of these courts, restraining the claimants from selling, transferring, assigning, pledging, encumbering, or otherwise parting with possession of the car, more particularly described as presently dispossession. So that's the car that's been the issue. Secondly is an order, and the reason for that, I'll come to that. And the second is an order for interlocutory mandatory injunction, directing the claimant to forthwith return and deliver the vehicle and the particulars of the vehicles and the other properties, the MacBook, iPad, work tool devices in its possession, pending the examination of the substantive suit. And we have a 9-paragraph ground in support of the relief sought, specifically highlighting or iterating the point that 1 is a status car, 2 is that before it got to this court, he's been given a letter which is exhibited that return these items, 4 items, Those items were not returned, albeit the council has said today that they are ready to return some of those items. My Lord, which would address in responding to this, because it's late in the day, my Lord. Also, except there's an order of court, an affirmative order of court. In support of the said application is 19 paragraph affidavit proposed to by Oladepo Oluyeka. And my Lord, the application is supported by a written address, and we urge your lordship to, and we respectfully adopt same, both the affidavits and then the address support. My Lord, again, just to highlight that what we demonstrated, and which was the reason why I wanted to argue together, is that on the face there, the specific complaint that we laid in relation to their own application, we tried to address it. We said that what is the basis for seeking this? Ayoride and AG Oyo, the case that I cited, my Lord, conspicuously referred to in paragraph 4.7 of the, and I urge your lordship to take a look at what it means to even give an undertaking and the competing rights of parties. We've also demonstrated on the face of the application and then the address, supported by the affidavit evidence, that in all of this, the concern that one, which is as relates to the first relief sort, arguably the relief sort can operate in the alternate. So even though not indicated on the, but to make this easy, I can easily say, concede I can operate in the alternate. If your lordship decides to give an order that it should not sell, it should not transfer, because any property that is, even a chosen action, can be sold, easily transferable to a third party who doesn't have a knowledge of this action and is a movable asset, or like a movable asset that would have expected that a due diligence exercise is conducted. So it's important to secure that order. But if the court decides to go with that order, it will be good to secure what makes that order one that is worthy of being implemented or being enforced at the end of the day. That is, it is not just to continue to hold the car, it needs to give a real undertaking that whatever is the value of the car, even if the balance is strong, it will be able to meet. And I think that is the soft land which we are thoughtfully put forward in this application. The other leg is the mandatory injunction. And my Lord, if we are to, and that's why the mandatory injunction is not the first order. Ideally, the mandatory injunction should be the first order, because the mandatory interlocutory injunction is one seeking the exercise of your lordship disciplinary jurisdiction. And we demonstrated on the fact that it has not come with clean hands, and those assets should be returned, because all the assets were listed. And as at when we are in court, as at when we file, the papers they've shown clearly show that they should have been returned. They decided not to, and that's why we just came to say, court, give us an order to ensure that all these properties are returned. And not, except I have anything to say in reply on point of law, I would leave it at this, and I hold your lordship to can the said application.
Okay, but you've not filed any replies on point of law. You are waiting to see if you need to.
No, my lord, we filed.
No, you filed. Okay.
We filed the reply on point of law.
Okay. Go ahead. Talk about it to me.
My lord, I reckon that my learned friend would want to speak to me.
Okay.
Yes. So
okay.
I should let him take the order of. Yes.
Okay. Let's hear him.
Lord, in reply to the application of the defendant, the claimant has filed a 17-paragraph affidavit. So 18-paragraph affidavit, my lord, dated the 2nd day of July 2026. In said, actually presented the facts for the guidance of my lord, Okay. In the affidavit, I point my lord to paragraph 7, where the claimant has provided evidence to show that there are 3 items in which the application before my lord by the claimant is seeking to recover. One is asking the claimant not to sell the vehicle, as well as the laptop and iPad. Those are three items, my lord, which they are seeking to do it. In paragraph 7, the claimant has provided evidence to say that, look, according to the company's policy, the laptop and iPad are fully amortized, and he has provided documents from the staff of the defendant to show that confirmation, my lord. In relation to the first paragraph, we've also provided evidence via affidavit evidence that the vehicle in question was paid for. My lord, just to give guidance, the vehicle was worth a certain amount, and the policy of the company did not cover that amount. So the claimant had to pay the difference. And it's our position that that difference we paid fully amortizes the vehicle, which forms for substantive part of the claim, my lord, because they are not denying that 3 years has passed. They are saying there's 1 more year. And we are saying that the amount we've even paid covers it. And in the event, my lord, finds that the question is a question of numbers, my lord, that the numbers do not tally and that the claimant should provide any succor. I've already indicated today in the other application, I'm willing to reiterate that the claimant is ready and willing and able, my lord, is a legal practitioner of over 20 years in a very, very prominent part of acting until a few months ago as company secretary and legal advisor for the defendant, a very, very notable industry. So, my lord, we stated in affidavit evidence that we're not selling it. And as Leonard Counsel has said, we're giving our affidavit undertaking, and we are willing to reiterate it that the defendant is not selling the vehicle and would not sell the vehicle until the matter is determined, my lord. We've also pointed out here clearly that he has maintained the vehicle in very good condition, my lord. If my lord orders today a survey evaluation of the vehicle, find that the vehicle has remained in pristine condition, my lord, at the expense of the claimant. My lord, we've also provided here evidence that he is willing to maintain it and that he doesn't believe that there are issues. My lord, they've touched upon the financial status of the claimant without providing any evidence, my lord, to that effect that he's not able to provide to meet the requirements of the amount in question, my lord. It's our humble submission, which we've also submitted this application with a written address of the same date, arguing all the illegal issues, that the legal rights of the claimant is present in this vehicle, and that as a result of that, the application should be rejected. We've also provided evidence to show that the balance of convenience favors the respondents, which we've arguably provided facts to that regard, my lord. And we said damages will not be adequate, my lord. Yes, the claimant has argued that the defendant has argued that the defendant is a PLC. My lord, we need to take cognizance of the fact that assuming the plaintiff was not terminated, he had less than a few months in which he would have amortized this, my lord. And that was taken away from him. We are arguing now, which forms part of the substantive claim, that his nature of termination was wrongful. And so if they go hand in hand, my lord, you cannot take a service status car which he has maintained, added value to, and then say because you terminated him, we should let it go. My lord, that forms the crux of our written address and the argument to put before you. And we humbly ask that the injunction should be refused. And just in the interest of justice, I will reiterate that, as Leonard's senior counsel has said, he is willing to take the application alternatively. We are willing to concede to the first part that we will not sell. And I reiterated, my lord, we will not sell pending determination of this honorable, the suit before my honorable lord. That is our application, and we ask that this injunction be dismissed, my lord. The most obliged.
Yeah, thank you. Thank you. My lord, in response, we filed a further affidavit deposed to by the same deponents and a reply on points of law. Both were filed on the 10th of July 2026. My lord, can I proceed?
Yes,
Yes.
you can go on. You can go on.
So, my lord, 3 things we adopt him and urge your lordship to grant the application. 3 things which are substantive issues of law, which I heard the court to take the application, that is to grant in line with the argument put forward. But three issues of law came up where my learned friend spoke, which I think I can deal with on the point of law. One is the issue as to that the claimant has a few months more to pay and to have the asset become his first asset. My lord, I hold your lordship not to consider the set of facts along that line, because that will be determining the substantive issue. And what the court has said, the Akapo Abib's case, which they cite,
Just hold on a minute. We are having technical issues here.
yes,
Hold on.
let's go, please.
Let's please just be a little patient. I'll be with you shortly.
But I have. Thank you so much.
That position might not be strictly cheering.
Steam's class happening in our work today. Okay. That's fine. Yeah, I'm watching to sports. So, yeah. Okay, I will do that. Thank you. Hold on, my brother. Thank you. Yes. Good. Thank you.
Hello, my lord.
Are you here?
Yes, my lord. I had to use my
Okay,
phone.
yes, Lana. So,
All right, my lord. Thank you, my lord.
yes, Counselor, I'm sorry for that time out.
No, my lord, it's okay. It's okay. It's perfectly
Yes,
understandable. Thank you so much, my
yes,
lord. So,
yes.
my lord, I was saying that on point of law, it is important that we restrict ourselves to dwelling for now on the facts that will support the grants and or the refusal of an application for injunction on both sides or either side. When my learned friend says that it's an unlawful until it was unlawfully terminated, when it says that your lordship should also consider that it has a few months to go to have fully amortized the vehicle. My lord, I heard your lordship that in making a considered ruling position on this, your lordship should not be guided by that. Those are mere sentiments, which there's a case they cited, which every time I go argue at the junction, I always like to put forward. And I always urge that if we understand the fact of Akapu, many of these things won't be there. So I would again cite Akapu Abib, which they cited in urging your lordship that matters of fact that will be considered a plenary, you should not even guide the lordship's decision. In Akapu Abib versus Akapu versus Hakim Abib, 1992, 7 SCNJ 199, and they cited the Nigerian Wiki Law. Karibi White said, and I'll quote my lord, it is of paramount importance to bear in mind the fact that the application before the court is for grant of interlocutory injunction, pending determination of substantive brought by the plaintiff. The duty of the judge in that situation is to ensure that it did not cross or determine the application and determine same issues that will come up for determination of the substantive action. My lord, looking at the claim of the claimant, he says he was unlawfully terminated. He says he is entitled to compensatory damages. My lord, I will not as much, so that I do not fall short of whatever prescription I was asking the court not to follow. I will not as much say that that claim is unsubstantiated. I can only say at this stage that that claim is in the realm of speculation, subject to when it is proven. But for the purpose of this interlocutory injunction that we are seeking to have all these assets back, it is all that your lordship will consider. They are issues of facts and not law or sentiment, pure facts. And in this case, leaning again on Akapu Abib, we have demonstrated and we are reiterating that position that indeed the assets that we're discussing here, the principal asset, which is the vehicle, is not one that is subject to sentimental value alone on the part of the claimant. It is one that your lordship will draw a convenient balance to say that as at the time the action comes up before the court, or is being at the time the application is being argued, who stand in a better position to be able to maintain the order. And my lord, I urge the lordship to take a look at the authority, which we've also cited, albeit we recognize that it is only persuasive because it was made by a brother judge of the NICF in a similar situation where the court had said that an applicant who comes to court via an interlocutory injunction to seek the employer from not retrieving the status card not be entitled to such an order for reasons which are clearly specified in that decision and which we say applies there. And that decision we've cited in paragraph 4.31. Emmanuel Aduku versus Lotus Bank, a suit number NICNA BJ 362-2025. Justice Subli was a decision decided 19th May 2026, just about a day or two when the applicant in this case was filing his own paper. That decision was made, and the facts are materially identical. He had sought to have status class still be retained in him, and the court said The principle of inadequacy of damages is inextricably linked to the balance of contents and serves as a crucial determinant. It requires the court to assess whether monetary compensation will constitute an adequate and complete remedy for the applicant if the injunction is refused. In the case at hand, it is abundantly clear that if the claimant were to ultimately succeed in improving his alleged proprietary interest or contractual right to purchase the vehicle, the monetary value of any proven contribution or market value can be fully and adequately compensated in damages. That's this court saying that as early as May 2026. The vehicle, while that of convenience, does not possess any unique, irreplaceable, or sentimental value that cannot be quantified monetarily. Status vehicle, while one of convenience, does not possess any unique, irreplaceable, or sentimental value. Therefore, damages will be an adequate compensation, entirely adequate compensation to the claimant in the event that the substantive case is resolved in his favor. My lord, it leads to a point of law that is inextricably tied to what they have also said. They also argue that we say that he is not in a position to pay whatever the value, or he will not be in that position. My lord, we did not say that. It is the facts that is put before the court. My lord, in UBN and Odushote, the Supreme Court said when you come to court to seek for stay of execution, stay of execution is a species of an injunctive relief. They all operate as equitable relief. It is your duty to demonstrate to the court that if at the end of the day, the appeal succeed, you will be in a position to pay whatever is the judgment sum you are trying to avoid for now. And Odushote, Supreme Court went further to say that you don't put that affidavit evidence, you demonstrate on your statement of account that you are in a position to meet it. My lord, not only has that not been put forward by the applicant, who is primarily seeking, the applicant, the claimant, not only has not been put forward by the claimant, who is primarily seeking to have that value, sentimental value. The claimant, the defendant counter claimant has demonstrated is owing the defendant counter claimant on the paper documentary evidence before the court, is owing the defender some standing up to the sum of 19 million as at the time it came to court. And we are not saying that on affidavit evidence. We provided document to show that he was asked to repay this sum that was owing the claimant. If that sum is not being paid as of today, that same claimant cannot come before the court and say that a sum that on the face of the paper, the court doesn't need to determine that a substantive issue because the documentary evidence shows as of today. That sum is not being disputed. Even if it's being disputed on the substantive, the position is,
my lord,
the
Leonard Counsel is arguing, Leonard Counsel is blowing hot and cold. He's arguing the substantive suits.
I'm only demonstrating why you raised the issue, and I cited the law that it is the claimant who says I can that must demonstrate it.
It is okay. We have everything on paper, and at the same time, enough is being said about this matter.
Yes.
So what will happen is, do you have anything to say on the other side?
My lord, I just want to say that the authority that the Leonard Silk cited
is your reply on point of law?
We made the point of law. He doesn't have any right again.
Okay, but I have the duty to say that Leonard Silk introduced a new authority which we did not provide.
That is the law. Then you can write to the court.
All I'm saying is, I know I'm not saying. I'm just saying Leonard Silk. I'm just saying my lord to take no cognizance of the authority. That is not on all points with what we have in our matter. Whether it's one month ago or 2 months ago, my lord should please look at it. And if it's not on all four, it should not be considered, my lord. That's our prayer. Whilst you guys say yes, I'm not bad. Thank you, my lord.
It's okay. It's okay.
Thank you, my lord.
It's okay, Lanshok. How I wish the law students have not left. Today would have been a very wonderful classroom. I love what happens in the courtroom because that is where the practicals happen, and it can be very interesting. We had a very interesting day.
My lord, I have had. On a lighter note, on a
Yes.
lighter note, the law
Yes.
students of today, when they come for law office attachment or law court attachment, I think they want to spend more time reading. They are quite conscious they are going back to school.
I agree with that. I agree with that. I agree with that.
Very few
I can
are
remember
interested
law
in
school how it
seeing.
was.
Yes.
We were always moving around with some folded papers. You understand?
Yes, right.
Yes, that was when law school was law school.
Yes.
I'm not happy about the balkanization of the law school into different campuses. Though, well,
I
things.
should take account of the number as well, my lord.
I
If
agree
it
with
is
you.
not done, then
Yes.
we would either have to resort to what was proposed some time ago, that law should be a second degree, or you have a situation where universities produce law graduates, but they cannot go to law school. Because, my
Oh
lord,
no.
actually all the private universities in Nigeria now offer law. So the
Ah,
graduates, so
yes, and even
problem,
now
sir.
AI wants to produce lawyers for us.
Aha. So I think it's
Yes.
better.
Well,
Then,
I have always wanted.
I'm of the
To
opinion
be a
that
lawyer, and I don't want to be anything else.
Yeah.
I'm of the opinion, my lord, that law schools
Yeah.
should be outsourced, and then the vocational aspect then reduce. Then you find the numbers reduce. A lot of people want to be solicitors and not litigators, but our few
Yeah.
system makes it everything that you must come out at everything. So if we have a system whereby, like in the UK, you can go to a not a law society to get your certification. Then you determine whether you want to become a barrister, and then we have a requirement for you to do maybe a privilege for 1-2 months, and then the solicitors teach you. The numbers will come down drastically. The numbers will
I
come
agree
down
with that.
drastically.
That is a very good
Lord,
point. I have never
my
looked
lord,
at it that way.
my learned friend has not filed his paper, so I want the court to discountenance the position. He needs to file his
Yes,
papers on what is the argument he's making now.
yes, yes,
It's a court
yes,
of record.
gentlemen.
So you
Thank
go and
you
file your
very much.
papers. Okay.
Thank you
So,
very much. We will send you. I will send to the parties a date for ruling.
as the
We'll
company is
consult our calendar, and then we'll give the appropriate notice for the day for the ruling as soon as possible.
as a complicity. But my lord, I know I speak the mind of my colleague when I say that we thank the court for the kind indulgence. I just looked up the time and I realized that we've been here for well over 1 hour, 30 minutes. And then I know
Yes,
that my lord has a number of cases. We thank the court for
we'll
allowing
have
us.
some other cases to attend to. Yes, thank you very
Without being
much,
an
gentlemen.
universalist, would we be able to get an indication of when trial may proceed, so that would also guide if
It
an
will be.
accelerated trial?
We are going to do the trial on the double.
Yes, my lord.
Yes,
I,
we'll hit the
On the what,
ground
my lord?
running, and then
Yes.
yes. Any subpoenaed witness?
No, at all, my lord.
none.
Not at all. What will
None at all.
happen is we are going to give, say, like 3 days
Yes,
consecutive hearings so that we can finish with the 7 witnesses.
yes, man. We are ready
Yes,
for that.
because we can do it if we make up our minds. We slot in a witness, he is cross-examined, he comes out, the next one enters. You understand? So
Yes,
let's
man.
make it like, say, yes, 3 days.
Yes, man.
Yes, it's all right. Thank you very much, gentlemen.
Thank
Have
you
a
very
nice
much,
day.
my lord. And you too, my lord. Thank you so much.
Thank
Very
you, my lord.
well.
Have a good day, my lord. Most
You
obliged, my lord.
too. You too. Very well then. Thank you.
Very well, man.